A police officer shot and killed Breonna Taylor while she slept in her own apartment. That is what most people believe happened, and I understand why. That is what most coverage of this case said. Here's the problem. That is not what the evidence showed, and more importantly, it is not what the law could work with. In this video, I'm going to show you something that almost nobody has explained about this case. Not the story, the document. One single document that set everything in motion, that determined what officers could legally do that night, what charges were legally available afterward, and why the legal outcome looked the way it did. That document is the warrant, and the warrant had a problem. This is the legal record. March 13th, 2020, Louisville, Kentucky, 12:40 in the morning. Louisville Metro Police Department executed a search warrant at 3003 Springfield Drive, the apartment of Breonna Taylor, a 26-year-old emergency medical technician. Now, before we go any further, I want to address something directly, because I know what you have heard about this case and I know where the gaps are. The most repeated claim about this case is that the police broke into Breonna Taylor's apartment in the middle of the night without any warning, that she was asleep, that it was a no-knock warrant, and that the officers gave no announcements before they entered. Here is what the evidence actually showed on each of those points, and why each one matters legally. The warrant. It was originally applied for as a no-knock warrant, meaning officers requested permission to enter without announcing their presence. But, and this is critical, the supervising judge, Mary Shaw, signed a modified version. She crossed out the no-knock provision and required officers to knock and announce before entry. Whether officers actually knocked and announced is disputed. Officers testified they did. Kenneth Walker, Breonna Taylor's boyfriend, who was present, testified they did not. No body camera footage captured the moment of entry because LMPD did not require body cameras on warrant executions at the time. The warrant authorized a search of the apartment for evidence connected to a drug trafficking investigation targeting a man named JaMarcus Glover, Taylor's former boyfriend. Investigators believed Glover had been using Taylor's address to receive packages and potentially store narcotics. Kenneth Walker, believing the entry was a home invasion, fired one shot that struck Sergeant Jonathan McKinley in the thigh. Officers returned fire. Breonna Taylor was struck 6 times. She died at the scene. No drugs were found in the apartment. That is the factual record. Now, let's talk about the legal one, starting with the document that made all of it possible. Legal Node 1, the warrant. To understand why the legal outcome looked the way it did, you have to understand what a warrant actually is and what the law requires to get one. The Fourth Amendment requires that no warrant shall issue except upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the things to be seized. Probable cause. That is the standard. Not proof, not certainty, probable cause. A reasonable basis to believe that the evidence of a crime will be found in the place that is to be searched. Detective Joshua James submitted the warrant application. In it, he made several claims to establish probable cause. He stated that he had confirmed through a postal inspector that JaMarcus Glover had been receiving packages at Breonna Taylor's address. He stated that Glover had been seen at the address on multiple occasions. And he stated that Taylor's address appeared to be used as a trap house for Glover's drug operation. Now, a Kentucky Attorney General's investigation, which examined over 3,000 pages of evidence, found something important about that postal inspector claim, The postal inspector had not confirmed what Jane said he confirmed. According to the AG's report, Postal Inspector Tony Gooden told investigators he had told Janes there was nothing suspicious about the packages going to Taylor's address before the warrant was submitted. And here is where we need to talk about the law, because this is the question I know you are asking right now. If the warrant contained false information, why did that not invalidate everything that happened? The answer is in a 1978 Supreme Court case called Frank versus Delaware. Frank's established a very specific standard for challenging a warrant based on false information. It is not enough to show that information in the warrant was false. You have to show two things. First, was the affiant, meaning the officer who submitted the warrant, made a false statement knowingly and intentionally or with reckless disregard for the truth. Second, that if you remove the false statement, the remaining information is not sufficient to establish probable cause. This is the legal framework the AG's office had to work with when evaluating Detective Janes. And this is where the case gets complicated in a way that most coverage never explained. The AG found that Jane's statement about the postal inspector was likely false, but establishing that it was made knowingly or with reckless disregard for the truth, the Frank standard, is an extremely high bar. And even if you cleared that bar, the remaining probable cause in the warrant, Glover's documented visible visits to the address, the pattern of activity, may have been sufficient on its own. That is not a comfortable conclusion, but it is the legal one. Legal Node 2. What the law says about what happened inside that apartment. When officers entered, Kenneth Walker fired. He struck Sergeant McKinley. Officers returned fire. 6 rounds struck Breonna Taylor. Here is the legal question the AG's office had to answer. Were the officers legally justified in returning fire? And here, as much as this may be difficult to hear, the answer under the law as it exists was yes. We covered Graham versus Connor in episode 1. The objective reasonableness standard, the 3-factor test. I'm not going to repeat the framework here. If you have not seen that episode, the link is in the description. What I will tell you is that the framework applied here too. Officers had a lawfully obtained warrant. They were executing it. A shot was fired at them. Under the Graham standard, under the Fourth Amendment analysis, officers returned fire after being shot at by someone inside the premises that they were lawfully entering is legally justified. The AG's investigation concluded that officers Cosgrove and Mattingly were justified in using their force. Officer Brett Hankinson, who fired blindly into the neighboring apartment, was a different matter entirely, and we will get into that. Kenneth Walker was initially charged with attempted murder of a police officer. Those charges were later dropped, and here's why that matters. Walker testified, and investigators found this account credible, and that he did not know the people entering were police officers. He believed it was a home invasion. Under Kentucky law, a person has the right to use force to defend themselves against what they reasonably believe is an imminent threat of death or serious physical injury. The question for prosecutors was whether Walker reasonably believed that the entry was a home invasion. Given the dispute over whether officers announced their presence and the absence of body camera footage to resolve that dispute, prosecutors concluded they could not prove beyond a reasonable doubt that Walker knew he was shooting at police. That reasonable belief standard, the same one that governed Brailsford in episode 1, was what was protecting Kenneth Walker from conviction. The law applies the same framework regardless of which side of the gun you are on. This is the question I know has been sitting with you this entire video. If the warrant had false information on it, if Breonna Taylor died, if no drugs were found, why was nobody charged for her death? Let me give you the legal record on that. The Kentucky Attorney General, Daniel Cameron, presented this case to a grand jury in September of 2020. The grand jury returned charges against one officer, Brett Hankinson, on 3 counts of wanton endangerment in the first degree, not for Breonna Taylor's death, for the rounds he fired that went into a neighboring apartment. Let me explain what wanton endangerment means under Kentucky law and why it applied to Hankinson but not to the other officers. Wanton endangerment requires proof that a person wantonly engages in conduct that created a substantial danger of death or serious physical injury to another person. Hankinson fired 10 rounds blindly through a sliding glass door and a window that was covered into an apartment where the trajectory of those rounds was completely uncontrolled. 3 rounds entered a neighboring apartment occupied by a pregnant woman and her family. And the other officers, Cosgrove and Mattingly, were not charged because the AG concluded that their use of force was legally justified under the Graham standard. They were fired upon. They returned fire. And the legal framework, as we discussed, produced the same result it produced in episode 1. The AG covered it up. He deliberately chose not to charge the officers. I understand why people believe that, but here is what the law actually constrained Cameron to work with. To charge Cosgrove or Mattingly with murder or manslaughter under Kentucky law, the Attorney General would have to prove that the use of force was not legally justified. Given that they were shot at first, given that the Graham standard governs officers to use force, that is an extraordinarily difficult legal argument to make beyond a reasonable doubt. Beyond a reasonable doubt. That is the standard. Not was it right, not should it have happened. Could a jury find beyond a reasonable doubt that the force was not legally justified? The Attorney General's conclusion, and you can agree or disagree with it, was that no. A jury could not be convinced beyond a reasonable doubt that officers who returned fire after being shot at exceeded the bounds of legally justified force. Now, Detective Janes, the one who submitted the warrant with the false probable cause claim. He was eventually indicted in 2021 on charges including falsifying a police report in connection with a separate warrant application, not the Taylor warrant itself, for a subsequent one. That distinction matters and speaks exactly how narrow the Frank standard is in practice. Here is what the police get wrong about this case when they say nothing happened legally. The city of Louisville paid $12 million in a civil settlement to Breonna Taylor's family in September of 2020. At the time, the largest settlement in police use of force cases in Louisville history. Alongside that settlement, the city agreed to a series of police reforms, including commanding officer approval for no-knock warrants, requiring body cameras to be active during warrant executions, and mandating that narcotics officers receive additional training before executing search warrants. In 2020, the Kentucky legislature passed the Breonna's Law, banning no-knock warrants statewide. Louisville had already passed its own version 2 months earlier. At the federal level, in August 2022, 4 Louisville officers, including Brett Hankinson, were indicted on federal charges. 2 of those charges related directly to the circumstances of the Taylor warrant. The Federal Civil Rights Framework, Title 18 U.S.C. Section 242, operates on a different standard than state murder charges. We covered the Federal Civil Rights Framework in the Brailsford case. Same statute, different application. Hankinson was acquitted on the state wanton endangerment charges in March 2022. He was convicted on federal civil rights charges in 2023. So here is the legal record on what happened after Breonna Taylor's death. a civil settlement, state legislature reform, a local policy overhaul, a federal indictment, and a federal conviction. Was that sufficient? That is a policy question, a moral question. It is not a question the law had the power to answer on its own. So let me give you the legal record on Breonna Taylor. Officers executed a warrant at her apartment. That warrant contained probable cause claims that the Kentucky AG's investigation found were likely false. The Frank standard for challenging a warrant based on false information, the 1978 Supreme Court standard, is a high bar that requires proving the false information was made knowingly or recklessly, and that removing it collapses the probable cause. Whether that bar was met is legally contested. Officers were shot upon entry. Under the Graham standard, the same standard we covered in episode 1, returning fire was legally justified. That framework produced the same result it produces in most officer-involved shooting cases. Not because the system failed, because that is what the standard produces. One officer fired blindly into a neighboring apartment. That produced criminal charges, wanton endangerment, for the danger created to the neighbors, not for Breonna Taylor's death. That distinction tells you everything about where the law drew the line. And the warrant, the document that started everything. The detective who submitted it was eventually indicted, not for Taylor's warrant, but for a subsequent one. The Frank standard, as narrow as it is in practice, is still the only legal mechanism available for challenging warrant applications after the fact. Here is what I want you to take from this case. The legal outcome was not a product of indifference. It was a product of a series of legal standards. Graham's, Frank's, the reasonable doubt threshold, each one operating exactly as designed, and each one producing a result that a significant portion of the country found deeply inadequate. Those two things can be true. A system can operate exactly as it was built and still fail the people it was supposed to protect. The question of whether these standards need to be rebuilt, whether FRAM needs to be recalibrated, whether Frank's bar needs to be lowered, whether the probable cause standard for warrant applications need additional oversight, that is a legislative question. Next week, we are going to stay inside the warrant framework but go somewhere different. We are going to look at a case where the warrant was not just wrong. It was used to target someone who the evidence showed had done nothing. And we are going to look at what the law calls a malicious prosecution and what it takes to actually prove one. Same framework, different failure point. That is the evidence table.